Right, thank you. I believe the majority have now joined, so we'll commence. Thank you all for attending today. My name is Leanne Cottrell. I'm the Immigration Manager at Sterling. I joined Sterling in 2012 to manage our newly introduced immigration service. I'm responsible for managing a team of both global and UK immigration consultants. However, my background is very much UK inbound immigration. I have extensive experience both as a caseworker and as a manager, and I've therefore experienced the majority of challenges our system has to throw at us. What I wanted to do today was to provide an overview of our current system, as well as some of its history to give us some context. The contents will be basic, but wide-ranging, hopefully to demonstrate that there is more than one type of visa for all. I'm more than happy to answer any questions at the end. However, do feel free to contact me afterwards to discuss any individual queries. A copy of this presentation will also be available afterwards. Immigration is a hugely contentious subject. Regardless of who you speak to, they always have an opinion, normally a very strong one. These opinions normally derive from experience, whether it's positive or negative, or more commonly, the press. It's surprising to note, however, that prior to 1905, there were no immigration laws. In 1905, the Aliens Act was passed and ultimately prevented refugees from seeking refuge within the UK. This only applied to aliens who were ultimately not from any part of the British Empire, and stated that they could be excluded if they were deemed to be undesirable. This was a bit of a subjective definition, but normally this meant those that could not support themselves. From the first step of an implementation of a system, however, the focus appears to be excluding those whose presence would have a detrimental effect on the UK. Realistically, a sound basis for our system. Apart from this relatively minor restriction, anyone could come and work in the UK. 1919-1920 saw the implementation of a work permit system. This was an employer-led scheme which stated that a permit could be granted as long as the employment was reasonable and necessary, as long as adequate efforts had been made to find domestic labour, and as long as the wages and conditions that the migrant would receive were no less favourable than those granted to a British employee for the same work. I'm sure to some of you these requirements sound fairly familiar. Very little changed throughout the following years. However, the situation was fully reviewed as a result of war and changes within the Commonwealth in 1948, 1949 or so. It wasn't until the 1960s, however, that restrictions were actually enforced with the implementation of the Commonwealth Immigration Acts of 1962 and 1968. The Acts initially saw a lot of resistance from the government, which happened to be Labour. However, they were then rashly implemented. Again, I'm sure to some of you, this actually sounds quite familiar. The biggest effect of the Acts were to deny entry to thousands of East African Asians who were UK passport holders. However, the more relevant to this session is the restrictions placed on Commonwealth citizens. In 1962, Commonwealth citizens became subject to a voucher scheme, with categories for those with a job offer, who were highly skilled or desirable, or who were low skilled with no offer. Surprisingly enough, the low-skilled category was abolished in 1965, as well as quotas introduced for the other categories. This then led to the implementation of the Immigration Appeals Act 1969. The foundation of our present system was laid with the Immigration Act 1971. Coming into force in 1973, the Act put an end to major permanent migration to the UK from Africa, the Indian subcontinent and the African Caribbean. Unfortunately, apparently due to pure coincidence, the Act came into force the same day that Britain joined the Common Market, or what is now known as the Economic Community. The Act was responsible for the formalisation of the work permit scheme and also enabled the Home Office to implement the immigration rules, which details the specifics of our immigration system. A change in political thinking then began with the implementation of the Nationality, Immigration and Asylum Act 2002. This introduced the concept of managed migration and the benefits of economic migration. Prior to this, the benefits of migration really were deemed to just benefit the particular individuals involved. Between 2000 and 2005, we saw a period of innovation and, to a degree, experimentation. The key themes of this time were meeting labour and skill shortages, encouraging innovation and entrepreneurialism, developing a self-financing system, and establishing a more rigorous system of control. This was elaborated on between 2005 and 2008. However, triggered by hostile public opinion and the volume of entrants from Eastern Europe, The concept of the points-based system was introduced in 2008 and 2009. The key themes of this time really did remain, except the theme of integration was added. The points-based system was designed to be objective, transparent, operable, usable, flexible, robust and cost-effective. The implementation was staggered to ensure correct delivery. Unfortunately, the government has spent since 2009 to present time fine-tuning the system. The points-based system is broken down into 5 tiers. The most common to us is Tier 2, which replaces the work permit scheme. This is then broken down into various subcategories, the use of which depends on the migrant's purpose in the UK as well as their previous employment. Tier 2 has changed significantly since the birth of the points-based system, primarily to lessen the number of those eligible for sponsorship as well as to meet the government's initial aims. Tier 2 General is to enable UK employers to employ nationals from outside the settled workforce to fill skilled jobs which can't be filled by settled workers. This route is primarily designed for new hires within the majority of sectors. The eligibility requirements have changed, however the founding criteria fundamentally remain the same, in that the migrant needs to be sponsored in a role deemed to be of sufficient skill level by the Home Office, the migrant needs to meet the set salary criteria, both for the category and for the specific role they are being sponsored in, as well as meeting the English language and maintenance requirements. Over time, these basic requirements have transformed, although all have fundamentally been in place since the work permit days. The skill level was initially set at NQF level 3, which is roughly the same level as A levels. Now, for the majority of industries, the skill level is set at NQF level 6, which is roughly equivalent to a bachelor's degree. What this has led to is a reduction in the number of roles which an individual can be sponsored in. Thankfully, the Home Office do have a relatively formal way of ascertaining the skill level of a role. The Home Office engage a committee called the Migration Advisory Committee, or MAC, who review data produced by the Office for National Statistics. They then consult with the various industries to determine the necessary requirements for someone to successfully fulfill a role, i.e. what educational requirements are needed, what previous experience is needed, and in turn, what salary should that role pay that individual for fulfilling the position. The figures are then amalgamated and a conclusion reached as to the skill level of the role. The recommendations are placed to the Home Office and then the Home Office decide whether to implement the same. Realistically though, the Home Office pretty much implement all of MAC's recommendations. There are of course exceptions to this. Roles that are deemed to be of a shortage, as well as certain roles within the creative industry, are accepted at a lower skill level. These skill levels also generally only apply to new applications within the category. Provisions are in place for those that are already being sponsored in the UK in lower level roles and wish to extend their leave or to change employers. There are 2 salary requirements we need to consider. Firstly, the salary for the category, which is currently set at £20,500 per annum, and secondly, the salary for the specific role. Salaries can include basic pay, guaranteed bonuses and certain allowances, and the salaries for the role are often reached following consultation with MAC. Some industries have seen bigger changes than others through the salary requirements for the role. Typically, the IT sector seemed to have seen some increases, although then there were also decreases. But the biggest change, realistically, is the implementation of 2 minimum salaries for the majority of roles. We have a rate for new entrants and a rate for experienced staff. This is a massive break from the previous model, which predominantly only saw 1 salary per role. What this often meant in practice is that to secure sponsorship, employers had to pay higher salaries to migrant workers than what they would have to resident workers at the same stage of their career. I'm sure the benefits of this are clear, but care must be taken. The Home Office have now undertaken to review the rates annually in every April, and indeed they have just done so in April just gone. If you have an application under progress, I would strongly recommend that you review it to ensure that your individuals are still eligible, although to be fair, a lot of salaries were actually decreased this April rather than increased. One other point to note is that if the migrant is applying to extend their leave beyond 3 years and 1 month, they automatically incur the experienced rate. Some roles, the experience rate is thousands of pounds per annum more than the new entrant rate. The business, therefore, must be prepared to pay the salary of the experienced rate during the lifetime of the migrant sponsorship. Lastly, we have the English language and maintenance requirements. The purpose of these, I'm sure, are pretty clear. Firstly, to enable an individual to be employed effectively in the UK and to integrate, they need to demonstrate that they can converse to a sufficient standard in English. And secondly, the migrant must be able to demonstrate that they are not going to be reliant on public funds to support them whilst in the UK. The way to meet the English language requirement has not changed. Realistically, the individual needs to be a national of a majority English-speaking country, or they can possess a degree level qualification which is recognised as being taught in English, or they can pass an approved English language test. What is deemed to be at a sufficient level has increased. Initially set at level A1, which is the basic formation of sentences and comprehension, it's now level B1. This really does not sound like a significant increase. However, in practice, the migrant now needs to be able to converse at a far higher grade. For some, this increase has not been too taxing. However, for others, it means that they often need to undergo months and months of English lessons to enable them to pass a suitable test. All this does is add delays and costs to the process. The maintenance requirement has not changed that significantly. The principle has remained the same, as has how you actually meet the requirement. Either your A-rated sponsor certifies your maintenance, or the individual provides evidence that they've held sufficient personal funds for a 90-day period prior to the application being submitted. Currently, the level of funds is £900 per day. However, this is due to increase in July to £945 per day. Dependents are also required to meet the maintenance requirement. One note of caution with this, though: by certifying the main applicant's maintenance, you are automatically certifying that of the dependents unless the Home Office are advised otherwise. The Home Office have recently started to formally review whether an application is genuine or ultimately plausible. There's always been a level of this previously, and any good advisor would always assure that a situation is credible and plausible. However, the Home Office have now adopted this within their requirements. So what it means is that they are actually considering whether the employer can genuinely able to offer the employment in question, and whether the actual employment on offer is genuine. Realistically, how the Home Office are going to do this in the majority of cases is yet to be seen. But one red flag that automatically raises suspicion to me is the number of hours an individual works per week. For shortage occupation roles, an individual must work a minimum of 30 hours per week. For non-shortage roles, however, there's technically no minimum limit as long as the salary requirements are met. So therefore, in my mind, if an individual is working a low number of hours per week, really is the employment on offer genuine? And in turn, is there really no resident worker that could actually fulfill that low level number of hours per week for you? Right, just to make sure that everyone's still paying attention, we're going to have a quick quiz. So in front of you, you'll see a polls section. Under this section, you'll see the question, which is what role is not eligible for sponsorship in new applications? If you could please select the answer you believe to be correct. So we have number 1, sculptor. Number 2, veterinary nurse. Number 3, police inspector. And number 4, nutritionist. Okay, so we'll just give everyone a couple of seconds or so to do that. And it seems actually quite a few people are, there seems to be certain ones that most people are favourable on, so let's see how this ends up. Okay, so 55% of you are saying sculptor, whereas 36% are saying police inspector. None of you are saying veterinary nurse. Unfortunately, you're all incorrect. The role that is not eligible for sponsorship in new applications is actually veterinary nurse. Okay, let's move on to the next question. So you'll see the question appearing, what country is not a majority English-speaking country? So number 1, Dominica. Number 2, Canada. Number 3, South Africa. And number 4, Guyana. Okay, so far the majority is saying Dominica even. Okay, it's fairly level. 44 to 45% of you are saying Guyana and Dominica. A few of you are saying South Africa, and no one is saying Canada. Well, 9% of you are actually correct. It's South Africa, which is not a majority English-speaking country. Therefore, South African nationals to qualify under Tier 2 General would need to possess a degree that's recognised as being taught in English or pass an approved English language test. Tier 2 General inherited a relatively long-winded and contrived application process from the work permit scheme. As a general rule, you must firstly show that there are no resident workers that can fill the role. We do this by placing compliant adverts in acceptable mediums for the set period of time. The required contents of the adverts have not changed significantly, although they are far more enforced now. It's not like the work permit days whereby if you accidentally forgot to mention something, you could argue your case with a caseworker and still get a work permit issued. The Home Office are extremely strict with the contents, and if there is one aspect missing, then it will be deemed that the resident labour market test has not been conducted correctly. The number of acceptable mediums, if anything, has actually increased, which is designed to give employers greater flexibility and also to enable more appropriate resident workers to apply for the roles. The one thing that has changed drastically, however, is the period of time the advert needs to have been live for. Back in the good old days, a high salary role could be advertised for 7 days and a lower salary role for 14 days. Now both incur a minimum period of 28 days. This is ultimately to enable resident workers better access to the roles. Once we've proved that there are no resident workers, the migrant can be assigned a certificate of sponsorship by the sponsor. The certificate acts as a work permit effectively and details the conditions of the migrant's employment, i.e. job title, salary and so forth. Surprisingly enough, the process to assign a certificate has changed significantly over the years and is now full of pitfalls. Previously, there was one type of certificate that was assigned to all. Now we have restricted and unrestricted certificates. This has arisen as a result of the government's desire to implement a cap on the number of migrant workers that could come to the UK. Unrestricted certificates, as the name suggests, are not part of the cap and are freely available to be assigned to those already in the UK or to high earners outside of the UK. A high earner is currently classified as someone earning an annual salary of over £153,500. Unrestricted certificates are the ones subject to the limit and have to be applied for specifically. Applications are only considered once a month, where a panel will evaluate the request and determine whether it is to be awarded one of the limited number of certificates available. The Home Office do this by utilising a prescribed matrix of skill level, salary, and whether the role the certificate is required for is deemed to be a shortage occupation role. To date, as far as I'm aware, the matrix has not actually been applied, as there has not been an instance where the limit has actually been reached. Last year, the allocation was significantly undersubscribed, and there was thousands of certificates in excess at the end of the year. Now we finally have our certificate. The migrant is now free to submit either an entry clearance application, if they're overseas, or a further leave to remain application, if they're within the UK. Once successful, the initial grant of stay will be awarded for a period of up to 5 years. Previously, the maximum period permitted was 3 years. The benefit for this, I'm sure, is clear, but it does incur a higher government fee. Some employers also don't particularly want to apply for a longer-term visa because they believe they're giving that migrant the expectation that their employment will actually exist for that longer period as well. Currently, under Tier 2 General, you can extend to a total of 6 years, subject to obviously meeting the extension criteria. The main benefit of Tier 2 General, ultimately primarily to the migrant, is that it leads to settlement or permanent residency in the UK after 5 years. Now, we've just got another quick quiz. So again, it's the same format as the previous ones. So the question that should be appearing is, what is wrong with this advert? So number 1, is it that a salary bracket is stated, not a specific salary? Number 2, there's no closing date. Number 3, the duties are too brief. Or number 4, the requirement of a foreign language cannot be stated. Okay, I do apologise. It looks like we're currently experiencing a slight technical problem, and it's not actually in front of you. But the actual issue with the advert is that there is no closing date on it. Now, I'm sure that this sounds such a silly problem for some, because it's not rarely that a closing date is actually put on adverts these days, but the Home Office are extremely specific that this must be included to give the resident workforce confirmation of how long they have to ultimately apply for this role. Realistically, for every advert that I review, the vast majority of issues that are wrong with them is that the closing date doesn't appear. Okay. So the main other category of Tier 2 for us is Tier 2 intra-company transfer, or ICT. This is designed for those that have been employed by a linked overseas entity. Please note there's a massive word of caution with this. It's not sufficient that they're only employed by a linked overseas entity. That linked overseas entity must be named on your sponsor license. Historically, the Home Office did not retain full records of what overseas entities were actually linked to the UK entity. They're actually going through a process now of updating their records, and if an overseas entity is not documented on your sponsor license as being a linked entity, potentially that Tier 2 application could be refused. I'd strongly recommend that if you have not updated your license recently, that you review this and that you update the Home Office to ensure that you don't encounter any problems with any subsequent Tier 2 applications. The intracompany transfer category is broken down into 4 subcategories, the use of which depends on the migrant's purpose in the UK. For longer-term work assignments in the UK, we have the ICT long-term category. This permits a maximum grant of stay for 5 years or 9 years if the migrant is considered to be a high earner. For shorter-term work assignments in the UK, we have the ICT short-term category. This permits a stay of up to 12 months within the UK. For recent graduates who are being transferred to the UK as part of a structured graduate training program with progression towards a managerial or specialist role, we have the ICT graduate trainee category. This enables a maximum grant of stay of 12 months. This category, however, is really designed for your highest caliber recruits, and therefore it is limited to 5 per financial year. Lastly, we have the ICT skills transfer category. This really is a gem of a category, and it is seriously underused. This permits those that are required to impart their specialist skills to the UK workforce or to learn skills and knowledge required to perform their roles overseas to come to the UK. The maximum grant of stay, therefore, is 6 months. Please note that work is permitted with this category, however, it must be in line with the training. Each category has their own requirements, although they do share some common requirements. Firstly, the skill level of the role. This is as per Tier 2 General, so for the majority of industries it's NQF level 6. There's also a salary requirement both for the category, the subcategory and the specific role. Even the graduates must meet this. The salaries for the specific role are as per Tier 2 General. There is also a maintenance requirement, again as per Tier 2 General, but there is no English language requirement. The salary requirement for the subcategory, however, does vary. The minimum salary for the ICT long-term category is currently $41,000 per annum, and the minimum salary for all others is $24,500 per annum. As with Tier 2 General, though, this can include the basic salary, guaranteed bonuses, and certain allowances. The salary can also be paid from within the UK or overseas. A key requirement which does vary for each category, however, is the length of previous employment with a linked overseas entity required prior to the transfer. For the long and short-term category, the minimum period required is 12 months. For graduate trainees, the minimum period is 3 months, and for skills transfers, technically there is no period required. However, the individual should be employed by the linked overseas entity on the date of application. I hope from this you can see why it is such a gem of a category. Technically, the employment overseas can be in any capacity. Thankfully, the Tier 2 ICT application process is far more straightforward and quicker than the general route. ICT certificates are not subject to a cap, therefore we just simply assign a certificate to the individual that's from your annual allocation. Once that certificate is assigned, the individual proceeds to submit their entry clearance application if they are outside of the UK, or further leave to remain application if they are within the UK. One huge downside with the ICT category, however, is that it no longer leads to settlement or indefinite leave to remain. I'd strongly recommend that if you are transferring any individuals to the UK under the ICT category, that this is stressed to the applicant. There are other categories within Tier 2. Ultimately, we have Tier 2 sportsperson and Tier 2 minister of religion. I'm not going to discuss these today, but please do feel free to contact me at a later point to discuss if you'd wish to do so. Now, there are some key points to remember with basically every category under Tier 2. Our first question is, who should actually sponsor the application? Sometimes the employer-employee relationship is actually not that clear. When determining who should be the sponsor, we need to ascertain who has responsibility for the migrant's duties and outputs. The sponsor is not automatically the company that actually pays the migrant wages. More and more common, it's becoming more and more common to encounter individuals that are struggling to encounter indefinite leave to remain purely because of the way that their Tier 2s have been structured. Secondly, we have the dreaded cooling off period. This is a 12-month period after the end of a Tier 2 visa, or 12 months after the migrant leaves the UK if this is earlier and can be evidenced, where subsequent applications under Tier 2 cannot be submitted. There are exceptions to this. Currently, high earners are exempt from this requirement, as are those who are applying under the ICT long-term category if they have previously been sponsored under another ICT category. Extensions or change of employment applications made within the UK are also generally exempt. Regardless though, this is a massive barrier to maintaining a fluid migrant population, and you need to strongly monitor the individuals that you are bringing to the UK to ensure that you are transferring those that are needed for a long term, and that by putting them in for a short term permit, you're not going to detrimentally affect their future. Lastly, we've got the change in Home Office's ethos. The Home Office have stated that those who benefit from migration should be the ones responsible for the management of it. So this places far more responsibility and obligation on the employer. This is ultimately gained by the implementation of the sponsor license. A sponsor license is mandatory for the sponsorship of any individual under Tier 2. It's valid for 4 years, and there are separate tiers for General and ICT, although the requirements of both are fairly similar. As long as the Home Office deem a UK employer to be capable, as well as genuine, trading, lawfully operating, honest, dependable, reliable, and trustworthy, a license is awarded. As you can imagine though, this trust comes at a price. With the award of a sponsor license, a UK employer also gains a massive requirement to be compliant with the Home Office requirements. Ultimately, these are ensuring that you maintain sufficient systems to enable you to check and monitor whether an individual has the right to work within the UK, ensuring that you have sufficient systems in place to monitor sponsored migrants' attendance and circumstances, and ensuring that you update the Home Office of any change of circumstances to both the migrant, nominated key personnel, and company where appropriate. The specific systems that you have in place are ultimately entirely up to you. However, you must ensure that they are fit for purpose, secure, recordable, and reliable. As soon as a license application is submitted, the Home Office have the right to conduct a site visit at your premises to ensure that you do have adequate systems in place and that you are a genuine trading company operating lawfully. Pre-award of license, a negative visit simply results in a refusal of the application. Post-award, however, a negative visit can potentially lead to compliance action involving the downgrade of your license to a B rating or removal of your license. A B-rated license means that any new applicants cannot be sponsored until you commit to the implementation of a sponsor action plan from the Home Office, as well as the cost of £1,476. If a license is revoked all sponsored workers could potentially be curtailed or cancelled, and a further licence application could not be made for at least a 6-month period. The Home Office initially undertook to conduct visits on every licence sponsor every 6 months. I'm sure for the majority of you, though, you'll see that this has not actually transpired. A trigger point for a visit, however, is realistically when you make a renewal application. If you have not made a renewal application yet but are due to do so in the near future, a visit really could be conducted as soon as you put that request in. And a huge point to note, visits can either be announced or unannounced. Therefore, ensuring that you remain compliant at all times has to be a priority. To ensure that you do meet the obligations, the Home Office require you to have key personnel in place for the duration of your licence, consisting of authorising officer who is responsible for the maintenance of the licence, including all users' activities, a key contact who is ultimately the main point of contact for the Home Office, and a level 1 user who is responsible for the day-to-day activities using the sponsorship management system. A new requirement to note, however, is that for new applications, the authorising officer must be the company's most senior person responsible for the recruitment of migrants. So far, the Policy Department at the Home Office have confirmed that there is no mandatory requirement to change existing authorising officers unless you need to do so for other reasons. But it is worth reviewing to ensure that the most appropriate person is fulfilling the role. A key benefit of the licence structure, though, is the ability to structure your licence based on the legal structure of your group. It's becoming more and more common for groups to have multiple entities within the UK. Recognising this, the Home Office will allow a licence to be applied for multiple entries, which gives you greater flexibility to have staff based at all entities throughout their sponsorship. The compliance risk for this, though, is increased. Strong systems need to be in place to ensure that all entities that are under the same licence are compliant. If not, and compliance action is taken, this will apply to all entities. As discussed, the points-based system does place more and more accountability and responsibility on those facilitating the visa application, whether it be the applicant, HR personnel, or legal representative. There is no check-in process in place for the majority of Tier 2 applications prior to the entry clearance or further leave to remain applications. This is a massive, massive step away from the work permit scheme, where everything was scrutinised prior to being granted or refused by the Home Office. Realistically, an unrestricted certificate can be assigned as long as all mandatory fields are completed and the fee paid. I cannot stress enough then the importance of ensuring that appropriate advice is sought where required, especially as the knock-on effect of a transparent system is that discretion by officials is not as freely utilised as it was prior to the implementation of the points-based system. One massive red flag for employers that has recently been released, which I want to bring to your attention, is the revision of the Prevention of Illegal Working legislation. Due for implementation on the 16th of May, the Home Office have advised that they'll be implementing revised civil penalties, so ultimately higher civil penalties, and a revised payment structure, as well as the revised timings that checks need to be conducted, although to be fair, this actually does work in the majority of people's favour, and a list of revised documentary requirements to prove that an individual has the right to work in the UK. The guidance has not yet actually been released by the Home Office, and this guidance will determine how this actually works in practice. However, as soon as it is released, I strongly recommend that you review it to ensure that you are fully familiar with the contents. The transparency of the points-based system is continued through the remainder of the tiers. We have Tier 1, or highly skilled, which historically focused on Tier 1 general. Unfortunately, however, new applications were stopped in 2010, so the category now focuses on Tier 1 general extensions, Tier 1 exceptional talent, which is for those with an exceptional talent recognised by an appropriate government body, Tier 1 investor, for those that have £1 million available to invest in the UK, and Tier 1 entrepreneur, for those that only have 200,000 available. Secondly, we've got Tier 2, which we've discussed. We have Tier 3, which is for low-skilled or seasonal workers. This was never actually introduced. Tier 4 is for students, and Tier 5 is for temporary workers, primarily workers within the charity sectors, religious workers, creative and sporting workers, as well as those coming to the UK under an international agreement, a government exchange scheme, or the youth mobility scheme. I just want to focus slightly on some of the Tier 5 as they can be very, very useful for individuals coming to the UK. Firstly, Tier 5 International Agreement. This supports a temporary sponsorship, so i.e. up to 6 months, of those coming to the UK under contract to provide a service under international law, such as the General Agreement on Trade and Services. This is a great way for a service to be provided where there is no ICT link between the UK and overseas entity. Secondly, we've got the Government Authorised Exchange Scheme. This permits an individual to come to the UK for a 12 to 24-month period to enable them to participate in approved exchange schemes that aim to share knowledge, experience and best practice. Whilst this cannot be used to fill job vacancies or to bring unskilled labour to the UK, it's a fantastic facilitator for developing talent within the UK. One thing to please bear in mind with this though, the UK employer cannot be a sponsor. The sponsor has to be an overarching governing body. Lastly, we have the Youth Mobility Scheme. This is more commonly known as the Working Holiday Maker Visa. This permits young individuals to be sponsored by their government to travel to the UK as part of ultimately a cultural exchange programme. Eligibility is therefore predominantly determined by nationality. So those currently eligible are nationals from Australia, New Zealand, Monaco, Canada, Hong Kong, Taiwan, Republic of Korea, and those that are British overseas citizens, British overseas territory citizens, and British nationals overseas. I focus on this category because it permits employment in the UK with no restrictions, apart from employment law, for a 2-year period. Care must be taken, however, that the intention of the category is followed, i.e. this category is intended to enable an individual to come to the UK for travel purposes so that they can experience the culture here. Employment is permitted, but it really should be enabled to fund these travels, not to enable the individual to develop a career here. The government's aim of implementing a fully transparent and contained system has unfortunately not been met. Some of the old rules remain. Whilst they are not widely used, they are a very useful aid for securing someone's work rights within the UK. Firstly, we have representatives of an overseas business. This is for multinational groups who have not yet established a UK entity, or the entity is in its early days of establishment, i.e. it's not yet transacted any business or employed any staff. This route permits an individual to travel to the UK for an initial 3-year period to enable them to establish or to develop that entity. This visa can then be extended and even leads to settlement in the UK. One word of caution with this, however, the individual must remain employed by the overseas entity. They can subsequently become employed by the UK entity, however for this, sponsorship must be sought. Secondly, we have the ancestry category. This really is another gem of a category and permits citizens of the Commonwealth whose grandparents were born either in the UK or on a British registered ship or aircraft, or if born before March 1922 in the current Republic of Ireland, to come to the UK. The actual purpose of this visa is to enable someone to undertake employment or even to look for employment. So it really is an employer's dream. It's granted for 5 years and even leads to settlement. Lastly, family members of certain individuals have full work rights within the UK. Those that have full work rights include family members of British nationals, those settled in the UK, i.e. they've been awarded residency or settlement, those with a time-limited visa, so for example someone on an ancestry visa or even someone under the points-based system, and those with and European Economic Area nationals. Now, nationals of the European Economic Area and their family members have the right to freely enter the UK. They have an initial right of entry for 3 months, and then after that period to be here lawfully, the EEA national must be deemed to be exercising a treaty right. A treaty right can be an economic treaty right, such as employment or self-employment, or the EEA national could be deemed to be self-sufficient, a job seeker, or even a student. Do review the slides that you can currently see. This contains the full list of current nationals of the European Economic Area. Whilst we have our standards on there that ultimately aren't anything too shocking, there are actually some surprising nationalities there, so it is always worth reviewing this. As the individuals have the right to work within the UK, they do not require a visa for employment. An exception for this, though, is their family members. Under regulations, family members do not need a visa to undertake employment. However, under prevention of illegal working legislation, they have to be able to evidence their right to undertake employment. This is typically in the form of a family permit or a residence permit endorsed in their passport. One exception to note, however, is Croatian nationals. Croatian nationals do not have full work rights in the UK, and therefore sponsorship is required. The reason for this is that the UK are able to implement proportionate transitional restrictions on any nationals of new member states to the EU. Proportionate is typically defined as no more than what was in place at the time of acceptance. Croatia were actually accepted in 2011, which means that an old version of Tier 2 is applicable. So the skill level is set at NQF level 4, and there's also no maintenance requirement. Now, these restrictions are due to be in place until 2018. However, once a Croatian national has worked lawfully for a 12-month period, they actually become exempt from requiring work authorization, although the national needs to be able to evidence this exemption. So we've discussed how to get work authorization for an individual. What if ultimately that individual doesn't need work authorization? This is where the business visitor category comes in very, very handy. Permitting a stay in the UK of up to 6 months, requirements include that the individual must not take employment, produce goods or provide services within the UK, must conduct at least one permitted activity, they must intend to leave the UK at the end of their visit, they must be able to maintain and accommodate themselves during the visit, and they must intend to live in the UK through frequent or successive periods. Now, I strongly emphasize the last requirement. This is a relatively new requirement, and it will start to bite those frequent travellers. So please do review the travel that your frequent travellers are making, and please do ensure that it can't be construed that their visits are frequent or successive, and if so, you really need to limit that travel. Another point to stress is the permitted activities. At first glance, they actually seem relatively clear-cut. However, it's not always clear. The Home Office will permit these activities to be conducted. However, the vast majority have certain caveats. So I strongly recommend that you do investigate it just to make sure that what the individual is fulfilling is actually allowed. The benefit of this route, though, is that it's far, far quicker than work authorization to obtain. For non-visa nationals, they can attend at the port of arrival and gain entry at the port, so much like they would as a tourist. For visa nationals, they must apply for a visa in advance of travel. However, most visitor applications are actually processed within 1 to 3 weeks or so it's really not a massive delay to them travelling to the UK. Caution must be used with this route, however. Whilst it permits a stay of up to 6 months, it really is designed for short, sharp visits, i.e. matter of weeks. It's not designed to be long-term, and it's not designed to enable the visitor to form any part of their life here. If there's any concerns with regarding the volume, the number or the length of visits, or if there's doubt about the actual activities that they're going to be conducting whilst here, I'd strongly recommend that you look to obtain the appropriate work authorization. Now, we do have another quiz, and fingers crossed everything will be working correctly. So, the same method as before. If you could please select the answer you believe to be correct. So the question is, can a business visitor receive a salary from a source within the UK? So number 1, yes. Number 2, no. Number 3, yes, but only if they work for a multinational company that processes payment of all salaries from within the UK. Or number 4, yes, as long as it is only for the period of their visit. Okay, so the vast majority are just going for number 2, so no. Let's just give it a couple of seconds though, just to balance out and to see what else everyone's thinking. Okay, so still the majority are saying no, it's just not permitted. 23% are saying yes, but only if they work for a multinational company that processes payment of all salaries from within the UK. I have to say 23% of you are correct. It is permitted, but only when the group structure determines that the salaries are processed from within the UK. Now, on to our second question. Same format as before. Which of the following are non-visa nationals? So these are the nationals that can enter the UK and gain entry at the port of arrival. So number 1, China, number 2, South Africa, number 3, India, and number 4, Brazil. Okay, so everyone's pretty much saying India at the moment. Let's see. Interesting. Okay, so none of you are saying China. Oh, you are now. 18% or so are saying South Africa, 50% or so are saying India, and 25% are saying Brazil. Well, I'm glad to say that actually 29% of you are correct. It's actually Brazilian nationals are non-visa nationals, which mean that they can gain entry at the port of arrival. Okay, so we've discussed relatively extensively what our current system is and also its history. What I wanted to end with is what is the future of the UK immigration system? To put it bluntly, I don't actually know. We're due some minor changes in May and July this year, but the biggest change to the structure of the Act has to be the implementation of the Immigration Act. Now, this actually only received royal assent yesterday. The implementation date is not yet ascertained. It could be the summer, or there are suggestions it could be later this year, although in theory it could be in the next weeks or so. So we do need to keep an eye out for this. What the Act aims to do is to reform the removals and appeals system, to remove the abuse of Article 8, which is the right to private life, and to prevent illegal immigrants from accessing and abusing services or the labour market. Now, the Home Office intend to do this by making it more difficult for illegal immigrants to live in the UK by requiring private landlords to check immigration status of tenants, by prohibiting banks from opening current accounts for migrants identified as being in the UK illegally, by awarding new powers to check the status of driving licence applicants, and by implementing the requirement for migrants with time-limited immigration status to make contributions to the NHS. From a business perspective, however, it may well be that there's very little change. The Home Office have previously advised that there will be no significant changes to our system for the foreseeable future. This will give us a period of much needed stability. However, I hope I've demonstrated that changes occur as a result of the government's desire or need to appease voters and to counteract negative press. Stability, therefore, cannot be guaranteed. I hope, though, that I've further demonstrated that whilst there is a lot of negativity surrounding our system, the foundation of it is actually fairly well-intentioned and sound. Now, thank you for attending today. Does anyone have any questions? Okay, so we've got one question already. So what is Article 8? Article 8 is the right to private life within the UK. So this is held under the Human Rights Act. And this is, I'm sure if you ever see in the press that people are being awarded the right to stay when others deem it unjustified, i.e., for example, you may have someone with a criminal conviction that's released from prison, but they're awarded the right to stay in the UK because they have a family life here, or they have certain ties to the UK, which would be disproportionate to remove those ties and return them to their home country. So this is ultimately the right to private life within the UK. So do we have any others? Okay, yep, we've got one more. Do you need to meet the resident labour market test with an extension application? I'm assuming this is Tier 2 general, and ultimately you do not need to unless the employment has actually changed. So if the individual is extending in the same role, same job title, same duties, same salary and so forth, there's absolutely no requirement whatsoever. But if there is a variance in the role, then it may well be required. So I'd strongly recommend that if you have got any individuals that are due to extend their visas under Tier 2 General, that you do review it well in advance, just in case you do actually need to advertise their role. Okay, one other question. Would you recommend certifying an individual's maintenance? Yes and no. This is completely a decision for the company. The vast majority of companies do tend to certify maintenance, although some don't. I would recommend it purely because it ultimately limits the risk of refusal of a Tier 2 application. I say that because the other option of meeting the requirement, i.e. that the individual evidences their personal funds, has so many other pitfalls in it. So for example, we need to ensure that they've always had the required level of funds for the set period, that the funds have been held in a bank that's recognised by the Home Office, and that they have sufficient document or evidence of that. The Home Office are extremely strict with the formatting of those documents. So as you can see, there's far more areas that application could fall down, but that is very much a personal decision of the employer. And if you are undertaking to certify the maintenance of your main applicants and their dependents, then you need to ensure that you relay to those individuals that they are not entitled to public funds whilst they're in the UK. Okay, so next question. Do we need to provide details of all overseas entities when renewing a sponsor license? Yes, I would recommend it. In the vast majority of renewals that I'm seeing at the moment for companies with ICT licenses, one of the actual requested documents from the Home Office is please fill out this form with all linked overseas entities. But even if it's not requested, I would still provide that information. Now, what you can do is just do this via an SMS update as well, so you don't need to wait for renewal stage. If it hasn't been reviewed for quite some time, you can obviously collate the required evidence of those links first, because it can take some time to organise the evidence, and then make that notification online and submit your evidence with the submission sheet to the Home Office. At the moment, they are updating records within a couple of weeks or so, although sometimes they can take months to do it. It very much depends on their workloads. So I'd strongly recommend that if you have an ICT application you're going to submit, even in, say, 6 months' time, that you do this activity now just to ensure that it is processed and updated before that application. Right, has anyone got any other questions? Okay, I believe that is it. So thank you all for joining us today. As advised, I am available to discuss any specific queries later on, and so my contact details are on screen. Please don't hesitate to contact me, and we look forward to hearing from you in due course. Okay, thank you all. Take care. Bye.